Mr. Radzivilovskiy. You may begin.
May it please the court. My name is Radzivilovskiy, and I represent the petitioner, the Iranian Community Association of New Benton, or ICANN-B. The issue in this case is whether ICANN-B is exempt from Local Law 117 for religious purposes, or, in the alternative, whether an expressive organization concerned with reinforcing Muslim beliefs and cultural values among its members qualifies as a private club protected by the First Amendment right to freedom of association, which includes the freedom to exclude non-Iranian people from its membership. ICANN-B is a legal entity that, among other things, specifically serves to reinforce Muslim beliefs among its members and preserve the Iranian cultural heritage. The club caters to the Muslim religion by providing halal meals and by hosting religious events. Since ICANN-B is primarily a religious organization, it excludes any person not of Iranian descent from membership. Ulrich Strauss is not of Iranian descent. Therefore, he is not qualified for membership. First, Local Law 117 exempts religious corporations, which is exactly what ICANN-B is. In ICANN-B's statement of purpose, it clearly says that the organization's intention is to reinforce Muslim beliefs among its members, support strong familial relationships, and preserve the Iranian cultural heritage. All of these are closely tied with religion. Although the respondent may try to say that the fact that the club provides meal service indicates public nature, the club specifically serves halal meals, targeting the Muslim religion. Additionally, the club hosts many religious events. In the New York State club case, the Supreme Court said that religious corporations are unique, and thus a rational basis exists for their exemption in the law. A law that is basically identical to the one in this case. Further, the Supreme Court said that religious corporations and benevolent organizations are different from commercial businesses. Here, ICANN-B is not only a religious corporation, but also a benevolent organization because it caters to the needy of Iranian and Middle Eastern immigrants. Second, assuming arguendo that ICANN-B is not a religious corporation under the state's definition, because that definition is unclear, the overarching principle at issue is the freedom of association. As the Supreme Court said in Boy Scouts v. Dale, the freedom of association plainly presupposes a freedom not to associate. ICANN-B is a private, expressive organization where the members share the principle that in order to get their message across, members should be limited to Iranian descent. Being forced to admit Ulrich would break that bond and undermine the message. As this court said in Dale, the forced inclusion of an unwanted person in a group infringes the group's freedom of expressive association if the presence significantly affects their ability to advocate public or private views. This court made a similar point in Hurley v. Glib. There, it held that it is unconstitutional to force an expressive organization to include in a parade other parade members that have a message the organization does not share. In doing so, the court stated that the parade organizers could exclude Glib just as readily as a private club could exclude an applicant whose views were at odds with the position taken by the club. Here, ICANN-B is an expressive religious private club, where its members are bonded together because of their heritage. Ulrich would break that bond and undermine the club's message. Therefore, the club has the right to exclude this applicant. Thus, Local Law 117 is invalid as applied to our case, even if its prongs classified as private. In the New York State club case, the Supreme Court, in response to a law that was almost identical to the one here, said there may be clubs that would be entitled to constitutional protection despite the presence of the characteristics listed in the law. As the law applies here, first, ICANN-B has over 400 members, but all of Iranian descent. And second, the club provides regular halal meals. Third, even if the club receives payment from non-members, it does not go towards furthering business. Lastly, I would like to draw this court's attention to a point the Supreme Court emphasized in Dale. As we give deference to an association's assertions regarding the nature of its expression, we must also give deference to an association's view of what would impair that expression. This court should rule in favor of the petitioner that Local Law 117 is invalid as applied to my client and reverse the decision of the Florence Court of Appeals. Thank you, Your Honors.
Thank you. you mentioned the fact that one of the statement of purpose is to reinforce Muslim beliefs, but isn't that one amongst many? And shouldn't they all be read holistically? Why are you elevating that one statement of purpose to be the sole aim of the organization?
Right. Well, one of the purposes is to reinforce Muslim beliefs, and that's one of the first points, and I think it's very crucial in this case. They also have another point which says that you must all be of Iranian descent. And as we know, in this type of culture, religion and culture are very intertwined and very close together. But I think just the reason that this club is suing is because all the members in that club share the view that they are promoting this religious message, and that all the members in that club have to be of religious and of Iranian descent. And we, as the court said in Dale, we give deference to an association's assertions regarding the nature of its expression, and at the same time, we must give deference to what it would view would impair its expression. And here, as in Dale, it thinks that including this applicant would impair that expression.
It's a religious club. Why wouldn't the club, for their membership requirements, like it says you have to be of Iranian descent, why wouldn't it just include that you have to also practice the Muslim religion?
Well, first of all, I think to make a point in this case, Ulrich is actually agnostic. So he doesn't share many of the principles that the Muslim religion has. And in fact, he wrote an article where he opposes many of those views. And one of the statements there is clearly that they want to reinforce Muslim beliefs.
But another one is that they also want to facilitate debate and discussion and disagreement regarding the Muslim culture.
That's true, but again, I think the club also has to have a way where it can draw a line. I mean, you can read a lot about the encyclopedia and learn about the Iranian culture. You can be a professor from a university and know about it. There could be a lot of people that know about the culture. But I think also one thing we have to make sure is that the Iranian community is also a minority group. And they're also trying to help other minorities. And in this country, we want to have every type of minority opinion be heard. And they're an expressive organization. And if all the members in that club share the view that this person would impair their message, we as the Supreme Court in Dale, we could also give deference to that.
But isn't the case that all share the view? Isn't it the board that makes the decision?
I think again we should look to what its statement of purpose is. And I think when the club was just founded, when it became legal, I think they made it clear, that they want this place where they would reinforce the Muslim religion, where they would focus on the cultural values. And in the statement of purpose, they said that they want this club to be that only people of Iranian descent. And I mean, there are Jewish clubs only for Jewish people. There are many different clubs like that, and we should allow them and give them that discretion.
How does Ulrich's membership in the club take away from their main purpose when he in fact grew up in Iran, speaks Farsi, and is very educated on the topic and has an Iranian wife?
Well, again, I think it's clear to say, that the club also has a right to, draw a line somewhere and see where it would admit an applicant. And if the members share the view that everyone must be of Iranian descent, then I think it's reasonable to believe that they could accept people of Iranian descent. I mean, this is very different from what we saw in the JC's case, where there was just this organization that admitted men, but it had no philosophy behind it, and therefore the court ruled that they should also allow women there. Clearly, in this case, there is a philosophy behind it, and if this was just, for example, if this was like a fencing club, and then suddenly they decided to be racist and admit only white people, that wouldn't be allowed.
Counsel, can you address the second prong? What if we acknowledge that it's a public club, and how is Ulrich thwarting their message? What's the argument behind that?
I'm sorry, could you rephrase it?
I'm sorry. With regard to the second part of your argument, if we determine that ICANN is a public organization, how is Ulrich's membership going to thwart their message?
Well, I think what we have to understand is if this essentially was a private club, was a public club, that would mean that they could, admit members who, who were completely different philosophies. That means that they could admit members who, didn't share their philosophy. And again, Ulrich is agnostic, so he doesn't believe in many of the things that, Muslim people and of Iranian descent believe in. So they would have to admit many people who would directly contradict their message. And I think, again, it's clear to point, the very big reason that, this has to be, that it's important that we allow them to be a private club is because we, in this country, we respect a lot of minorities' views. When the founders wrote the Constitution and the First Amendment, that's exactly what they were thinking of. And if there's an expressive organization and it has a clear message, then we should allow them to express that message. And if it was a public club, they wouldn't have the opportunity to express that message.
It's like 30 seconds left. Thank you, Counsel.
All right, thank you very much, Your Honors.
Would you like to